The first point I want to talk about is process. I think Australians have a reasonable expectation, including those sitting in the public gallery, that when legislation is introduced into this place, which is hundreds and hundreds of pages long, and then hundreds and hundreds of pages of explanatory memoranda, that in this House of Review, the senators in this House of Review should have sufficient time to closely scrutinise the legislation. And a consequential amendments bill that is longer than either. Now, we simply didn't have the time to scrutinise this legislation as well as I would have hoped, or probably others in this place would have liked. And that should be a matter for reflection. And this wasn't a comment just made, or isn't a comment just made by me as a senator in this place. There was an abbreviated House of Representatives committee process that was instigated just before Christmas. Submissions due on 18 January. Is that a good idea? Hundreds of pages of legislation, hundreds of pages of explanatory memoranda, very complicated legislation. You start the inquiry mid-December, submissions by mid-January. What's wrong with that? So, and it was actually held up as a positive that this bill was subject to an inquiry in the House of Representatives and an inquiry in the Senate. We would have been better off having an inquiry instituted in the Senate back in mid-December and have one inquiry which provided sufficient time. But unfortunately, that no doubt is out of the hands of the majority government members on the committee and is in the hands of the Attorney-General, so the Attorney-General can reflect upon that. Second point, this Senate asked this committee to report by 24 July. 24 July. Now, that's over 2 months away. And it was brought forward, the reporting date, on very short notice, and again I'm not reflecting on the majority members of the committee, such that I, as the deputy chair, I had one clear business day to look at the majority report. One clear business day. I had Friday. I got the majority report on Thursday, late Thursday. I had Friday to look at it, and I had to get my report in to Secretariat by Monday morning, 9:30. I did my best. I did my best. And I did my best to cover as many issues as I could that weren't covered in detail in the majority report. But that is not a satisfactory process. That is not a satisfactory process. And there are matters which should have been dealt with in the majority report, really substantial matters, which I'll get to, which weren't touched upon in the majority report in detail. And from my perspective, again, that is far from best practice. There are even witnesses called to public hearings, and I even asked for certain witnesses to be called to public hearings. Because of the lack of time, which Senator Cash referred to, I didn't even have time to ask witnesses who I asked to be called questions. I mean, that's embarrassing. It's embarrassing for us as an institution, and I apologise to those witnesses, and I do thank them for the submissions they made because they were detailed submissions. Second point I want to make is around the case for reform. Now, I'm glad, I really am glad that there are people in the public gallery who are hearing this. I like an audience, Acting Deputy President, don't we all? But this is the justification. This is what the government said in relation to this reform. And I want to read these statements out, and then I want to tell you what the objective evidence is and see if you can pick the difference. The majority report says the regime had lost the confidence of all stakeholders. So they're saying the Administrative Appeals Tribunal had lost the confidence of all stakeholders. And the merits review system was badly in need of a complete overhaul. That's what the majority report says. And then the Attorney-General said the AAT no longer enjoys the trust and confidence of the Australian community it serves and is not fit for purpose. I mean, those are pretty dramatic statements. Pretty dramatic statements. And I would have thought if you're prepared to make those statements, you should also be prepared to consider the objective evidence. And that would include how the people who actually use the AAT, the Australians who go through the Administrative Appeals Tribunal, actually judge the AAT themselves, their satisfaction rates. But that wasn't referred to at all in the majority report. That evidence, and those in the gallery, those listening, they can go to the AAT's annual report and look at the evidence themselves. It wasn't even referred to in the majority report. It won't be referred to in any of the speeches, I'm sure. I'm not Nostradamus, but I'm sure it won't be referred to in any of the speeches from government senators. I want to put this on record. In the annual report for the year ending 30 June 2023, so this was at the time when the attorney's attacking the AAT. It's lost the confidence of all Australians. It's a disgrace. The overall result for user experience with the AAT was a rating of 72%. Now, does that sound like an organisation that has lost the confidence of all stakeholders? 72%. And the KPI was 70%. And then, in terms of representatives, so the lawyers and people representing people who go through the AAT, it was even higher. The user satisfaction rate was even higher. So the people, the lawyers, the ones you'd expect to have more experience dealing with the AAT as part of their job, the satisfaction rate was even higher. Then we get to this KPI with respect to fairness. Now, I would have thought this is a key point. And fairness, the courtesy and respect shown by members and registrars, the opportunity given to parties to present their case, and overall perceptions of the fairness of the review and independence of the AAT. Right? Key performance indicator. What were the results? Satisfaction rating of users was 77%. 77% said they thought it was fair, they were treated with respect, it was independent. 77%. And then their representatives, the lawyers, other people, advocates who appear regularly, it was 82%. 82%. Does that sound, on any objective basis, does that sound like an organisation that has lost the trust and confidence of all stakeholders? I don't need to answer that question. But the disturbing thing is that data is not even referred to in the majority report. They don't even try to deal with that issue. Don't even try. There's not even an attempt to deal with that issue. The last point I want to make is in relation to a number of issues that weren't dealt with in the majority report. And it's a shame that a number of these issues weren't dealt with. There wasn't time. And one of these issues, I'll touch on a few of them. One was in relation to constitutional issues. And there were some very, very good submissions made in relation to whether or not the President of the Administrative Review Tribunal should be a Justice of the Federal Court. And to put it in simple terms, the concern is that that mixes a court with a tribunal, which is part of executive government. So should there be that mixing? Does it raise too many constitutional issues? And there were some very, very good submissions made by Mr Gary Connolly of Council, and there was quite a reasonable response to that from the Attorney-General's Department. But it is an open question in my mind as to whether or not it is best practice, having considered the matter, to have a judge of the federal court as the president, whether or not it might be better to have a retired federal court judge or a retired senior member of the AAT as president. I think that's a reasonable open question. The second point I want to make is around costs. There were very good submissions made by a whole range of stakeholders that the Administrative Appeals Tribunal should have the discretion in exceptional circumstances to award costs to an applicant. And that is especially given that we're introducing this additional layer Senator Shoebridge referred to, the Guidance and Appeals Tribunal. So you might have a situation where someone applies to the AAT, they win their case, and it's thought, well, we're going to elevate this to the Guidance and Appeals Tribunal because we want the Guidance and Appeals Tribunal to look at this case. It could set a precedent, and it might be useful for the broader public for it to be elevated. Now, I strongly believe in that situation the costs of the applicant should be in some way reimbursed because their case is being used for a public good. Second point is there are situations where Commonwealth departments, the bureaucracy, doesn't necessarily follow what we refer to as the model litigant rules. And bear in mind, I'm not trying to be a comedian, Senator Shoebridge. Bear in mind, I could follow the acting deputy president's example. He's got better material than I do. There are situations where Commonwealth departments don't follow the model litigant rules. That means they don't necessarily conduct themselves as they should. They're dealing with a private citizen. You've got a private citizen against a big bureaucracy. If the government department doesn't do the right thing, I think the average, ordinary, everyday Australian deserves to get their costs. That's my view. They do it at state tribunals. I don't know why we're not doing it at a Commonwealth level. That's the last point in relation to costs. My final point is the attorney has been on the record stating his concerns with respect to a particular cohort of members who were appointed to the AAT under the previous government. He's given particularity, precision, with respect to the number of those members appointed by the previous government. He said up to 85. Now, that triggers a concern in my mind as to whether or not those members, when they apply to become members of the ART, whether or not they're going to be treated fairly. And please know, I touch upon this in the majority report and some of the evidence which we received in terms of processes, and the panels are populated with some very eminent former judges, which gives one some confidence. But please know this is perhaps the first test of integrity of this process. And the last point in relation to that, and I think this, I genuinely believe this was unnecessary and unworthy. The loss of office compensation direction of our independent remuneration tribunal is being overridden by this bill. So our independent remuneration tribunal has independently decided this is what someone who loses their office when something like this happens should be paid, and this bill is introducing a different compensation scheme. I don't think that's appropriate. One of our witnesses, a professor of administrative law, said that's bad public policy. I don't think parliamentarians in this place should be determining the remuneration of office holders of Commonwealth entities. There's a reason we have the Independent Remuneration Tribunal. I think it's quite unseemly that their independence is being overridden by this bill.